Welcome to the Labor Guild's Conversation Corner. My name is Lisa Field, and I'm president of the Labor Guild. Dan Fogarty is joining me tonight to talk about the National Labor Relations Board's Cemex decision. Dan is a partner with Sandulli-Grace. He's also a beloved faculty member at the Labor Guild. So welcome, Dan.
Thanks for having me, Lisa. I'm really excited to be here.
We're very excited to have you. So before we get into what the Cemex decision was all about, how about we back up a little bit and give some context for folks? Like, what was the process before Cemex happened?
Absolutely. So the board's Cemex decision tells us what happens when a union with majority support in an appropriate bargaining unit requests recognition from an employer. So previously, when a union can always ask for voluntary recognition from their employer when they have the support of a majority of the employees in an appropriate bargaining unit, an identifiable group with similar interests. Before Cemex, the employer was allowed to just say no, or arguably just ignore a request. They could refuse to recognize the unit until the union actually won a board election. And there was no affirmative duty to act after the request was made. So they could essentially tell the union to go prove it, right? If you think you've got majority support, go to the board, get an election, and we'll see what the votes come out as. So the union would then have to file a petition with the board, start the election process, which can take several weeks to much, much longer as the process can get drawn out with litigation. And during that time, the union and the employer would both run campaigns, right? A vote yes or a vote no campaign. All too often, an employer would engage in a coordinated campaign, often very well funded, to undermine support in the union. And ultimately, a lot of the time, the employer violates the National Labor Relations Act. So in those cases, if the employer's campaign was successful, the union loses, right? After having majority support, they end up losing the vote. The union then has to file, exceptions and unfair labor practices and go to the board looking for relief. And that litigation in the past can take quite a while. I mean, one example, it's not really related to Cemex because I don't think it has anything to do with majority support. I don't know if they ever had majority support in the unit. But if you think about the Amazon organizing in Bessemer, Alabama, they've already been through 2 elections. That campaign started in 2020. They had 1 election. They went to the board. They got a rerun of a second election, and now that election is being challenged as well. So over the course of 4 years, we're still dealing with that campaign. So in cases where the union proved that the election needed to be set aside because of the employer's misconduct, the board would typically order a variety of more traditional remedies and then rerun the election. So they may issue a cease and desist order. They may, order the employer to reinstate employees that were disciplined in a retaliatory fashion. They may provide a union with access to employees and then rerun an election. Previously, the board could order an employer to recognize and bargain with a union in certain pretty extreme cases where the union proved that the possibility of erasing the effects of the unfair labor practices made it, nearly impossible for a fair election to take place. This was incredibly rare in the past. Cemex seems to change that.
Great. Thank you. That context, I think, is helpful for everybody to you need to understand what happened, what was the process before to understand kind of what the decision was. But before we get to the actual decision, so what were the facts of the case?
Sure. Yeah. So the Cemex decision comes out of a Teamsters organizing campaign at Cemex Construction Materials. It's this multinational building materials company. It's a big publicly traded company. It started in about 2018 when a group of ready-mix concrete truck drivers and driver trainers who worked for Cemex in Southern California and Nevada began organizing with Teamsters. It was approximately 366 employees that were identified as being part of an appropriate bargaining unit. And the Teamsters ran an active campaign. It was a visible campaign with many of the workers participating directly in the organizing effort. So, some examples of that: pro-union drivers met regularly on conference calls. Organizers distributed union stickers and other paraphernalia. They, distributed information about the union, and they were incredibly active on social media. So they were seen as supporting the union. There were photos and videos of pro-union drivers posted. Um, and, as that progressed through 2018 and into the fall, the board found, in evaluating the case after the fact, that the union gained broad support during the campaign. And the union actually had valid signed authorization cards from at least 57% of the bargaining unit shortly before filing an election petition. So in the fall of 2018, they had majority support. They filed a bargaining petition for an election in December of 2018, early December, like December 3rd. In response to the union's efforts, the employer began a pretty aggressive anti-union campaign in the fall of 2018. The company created what they called a steering committee to coordinate its response, and that committee included a number of high-level officials from the region, along with other employees. They also hired these high-priced consultants to train their managers and supervisors on how to address the union campaign. The board noted in its decision that the company spent more than $1 million in less than a year on these consultants.
Wow.
Cemex held regular, at times daily meetings with their employees to persuade them to vote no. And the company also created these mass communications, these videos for employees to watch in the lead up to the election. And a lot of what they did were purposefully walking right up to what we'd say walking right up to the line as far as what's permissible in these activities. And as we'll cover in a moment, the board ended up finding that in a number of situations, the companies crossed that line and that their tactics violated the law in their campaign. So after that campaign, the election finally happened in March of 2019. So that's probably about 4 months after the election petition was filed. And the union ended up losing. They started with 50% or 57% support. They end up losing 166 to 179. It's a swing of just 7 votes would have made the difference. Incredibly close for a unit that size. And so after the election, the union filed exceptions and unfair labor practices against the company, which eventually led to the board's decision.
Mm-hmm. And so what was the board's decision? Let's start with that. What actually, how do they rule? And then we'll go on to what it means.
Yeah. So, the NLRB determined that Cemex committed more than 24 ULPs.
Wow.
Before, during, and after what they call the critical period. So the board will often look at what they call the critical period, which is between when the union filed its election petition and when the election actually takes place. And that's a period of time where they're going to be very concerned about unfair labor practices occurring because they undermine the free and fair election that's supposed to be taking place, the laboratory conditions, I think, as they say. So the board ended up identifying a wide array of unfair labor practices. Like I said, there was more than 24. Some of them were about surveillance of union activity. Some examples of this, was members of management hanging around the facility gate and waving to people as they tried to talk to union organizers or as they drove past the informational picket. Asking employees why they were wearing union stickers. Why are you wearing that on your helmet? Where's your vote no sticker? Why aren't you wearing a vote no sticker? They also found that they announced overbroad rules, which limited when employees could communicate with union organizers and created confusion around what was allowed. Mm-hmm. And they blamed the union. I mean, this is one that you hear a lot. They blamed the union for delayed wage increases, saying, oh, this campaign is stopping us from giving you a raise. And they threatened that there would be less flexible working conditions in the future if the union came into play. And then right before the election, they added a number of additional security guards, which the board found was intended to intimidate the workers. So that's kind of a cross section of a number of the ULPs that they found. But the board also focused on 3 specific types of ULPs that they found specifically concerning as far as undermining the fairness of the election. The first of those were threats of plant closure. So they found that a number of top officials in the region made threats about closing plants if the union were to come into play, which, ultimately was a threat that people would lose their jobs. And there were other supervisors and consultants, some of those high-priced consultants that they brought in, made threats that Cemex would just shut down the related operations or, move them out of state. They relied on this idea that this is a big multinational company that can be flexible. We don't need, these trucks driving from these places. We could find other ways to do this if we had to. Threats like that, which, ultimately was something that the board found incredibly, concerning. Another thing that they did was they made implied threats that workers would lose their job if they engaged in protected striking activity. I thought that this one was interesting, and the board found it, especially concerning, because one of the things that the employer did, one of its broader themes in this campaign, was that the Teamsters was a union that liked to strike, right? And it tried to rely on the Teamsters' history as a group that would strike more regularly to say that it was going to create disruption in the workers' lives. And so there were a number of times where they implied that strikers wouldn't be able to return to work. And they weren't careful about how they talked about it. They didn't talk about it within, the details of how the law works and operates around those issues. And they implied that people would lose their job for engaging in protected striking activity, which was, again, very concerning to the board. And then the final category that they looked at of these three major types that they found concerning in undermining the election was unlawful discipline of one prominent union activist, an employee that had been very engaged in the union organizing program, was reprimanded, suspended, and then after the election ultimately terminated. The board found that that discipline was unlawful and retaliation for union activity. Ended up, addressing that in the ULP, but also found that that was something that was concerning. It was a signal to other employees that participating in the union, that acting as a union activist was going to create issues for them, right? For the employees. It created a chilling effect that employees would be concerned about associating with the union, that they may face similar consequences or harsh treatment. This part of these things is that these issues occurred during the critical period. It's also that these issues, were particularly distressing to employees who would know about it. This idea that it would be a long-lasting concern of the employees that if the union were to be elected, if the union were to come in, that these things were something that management could do, especially around plant closures. One of the things that the board touched on was, when an employer threatens to do things that are kind of uniquely within their management rights, usually, right? When they threaten to do those things in retaliation, there's a real concern that the employees or a union, if the union is in place, could have a hard time challenging those actions. We've seen that in real life from time to time with plant closures and other issues. There's not always a good way to fight back against that if the employer follows through on that threat. That's another thing that the board took into consideration when evaluating those ULPs. Ultimately, as a result, looking at all of the ULPs that took place, especially those three major types, the board ended up deciding to set aside the election, and they issued what we call a remedial bargaining order. They ordered the employer to recognize and bargain with the union. Now, when it did that, the board, in its decision, it found that a remedial bargaining order would have been appropriate even under the old standard that we talked about, essentially saying that in this situation, the employer's conduct was so extreme that a bargaining order would have still been appropriate, even where that heightened standard, where it's relatively rare to give as a remedy, if that were in place. But in addition, why we're talking about the case now is because they also announced a new standard that would apply in this case, and they analyzed it around this case, and in all other similar cases that were pending at the time and going forward.
So you can talk a little bit more about that standard and what were the implications from the decision?
Absolutely. So, you'll remember we walked through at the beginning of this kind of what the standard was before, and, the union was forced to be in the driver's seat and to move this forward. And the employer didn't really have any obligation to act when the employer came to them. Well, that changes now. So the union still has an opportunity to make a demand for recognition. So the board clarifies, and what's helpful is the general counsel has also issued some guidance on this to give us a little bit more detail about what to do. So the union makes a demand for recognition. This can be verbal or written. They're clear that there's no magic words or a specific form to have to do this, but the request must clearly indicate a desire to negotiate and bargain on behalf of employees in the appropriate union. One of the ways that a union can do this is still just by filing an election petition. If they fill out the election petition in the correct way, they can indicate that they currently have majority support and that, the petition should be considered a demand for recognition as well as a demand for an election. And so that's one way that they can do that. The more common way to do that is by providing or collecting authorization cards that clearly state that the purpose of those cards is to show that the bargaining unit member supports the union and wants that union as their representative, and collecting a majority from a majority of the potential bargaining unit members is kind of the common way to show majority support. So they have to make that request to a representative of the company. There's not a specific designated person that it has to be, but it has to be someone that's in a position that would receive that type of request. And they have to clearly state what the proposed bargaining unit is going to be. So as we talked about before, there's nothing changing about that standard. It's got to be a group that's identifiable and shares what we call a community of interest, has a similar job, similar working conditions, that sort of thing. So once a union does that, before the employer could just brush them off. Now they're obligated to do essentially one of two main options, really one of three things. The first thing that they can do is they can agree to recognize the union.
We wish that was easy, right?
So if the union has majority support, the employer can just recognize them. They're allowed to ask to see the cards that the union's collected. The union doesn't necessarily have to share them. They could get a neutral party to review the cards. But what's important for the next step is that, kind of investigating whether majority support exists doesn't toll the period of time for the employer to act. Because if they don't recognize the union, what the employer is now obligated to do is promptly file a petition for an election themselves, testing the union's majority status. And what the guidance from the board now says is that when they say promptly, they mean within about 2 weeks. So the employer's got 2 weeks from the time that a union makes a demand to file a petition for an election if they're not going to voluntarily recognize the bargaining unit. In theory, I said there was a third option. If the union's already filed a petition for an election, the employer is allowed to just play out that process. So in that situation, the employer wouldn't have an additional step at that point. But so then the question becomes, what happens if the employer doesn't do that? So they now have, they're now given this obligation that they have to act once a demand is made. And so if an employer fails to act following a demand, so 2 weeks pass and the union doesn't recognize them and hasn't filed a petition, the union can file a charge for an unfair labor practice with the NLRB. They can accuse the employer of violating Section 8A5, which we refer to, which is that they're refusing to recognize and bargain with the union. Now, in defending themselves, the employer can still challenge the basis for their bargaining obligation. So they can say, well, the union still has to prove that they have majority support, or the union still has to prove that it's an appropriate bargaining unit. But what the board has said is that if a union demonstrates majority support in an appropriate unit, the board will find that the employer violated the act by failing to recognize and bargain with the employer or filing a petition to run that process. And as a result, they're prepared to issue a remedial bargaining order for doing that. So in theory, if an employer fails to respond to a union's request for more than 2 weeks, that could end up leading to a bargaining order that dates back to when the original request was made. And so they would have had to maintain the status quo. They couldn't have made any unilateral changes. And they'd have to bargain a contract from that date. That's a big change. So the other thing is, even if the employer, this is kind of what's grabbed the headlines, even if the employer does promptly file a petition for an election, then if during the period of the election they commit, and what the language says is at least one ULP that renders the recent or pending election a less reliable indicator of current employee sentiment than a current alternative non-election showing, meaning the majority authorization that they had in the first place. The petition will be dismissed, meaning the election will be thrown out, and the board will issue a remedial bargaining order. So what does that mean? Mm-hmm. So if the employer commits an unfair labor practice during that period between when the petition is filed and when an election takes place, if they retaliate against employees for their union activity, or if they intimidate or coerce or threaten the employees in a way that, is, quote, not so minimal or isolated that it's virtually impossible to conclude the violations impacted the election. So in any significant way that they've threatened or coerced these employees, if the employer does that, then even if the employer wins the election is going to be thrown out and a bargaining order is going to be issued, just like it was in Cemex. And so, what's interesting here is that, and we'll talk about this more in a minute, but, it says at least one ULP. In Cemex, they had 24 or over 24. I can't remember what exactly the total count was. So now, in theory, it could be far less. They do say, and in an effort, I think, to conform with kind of what the law requires and under the federal precedent right now from the Supreme Court and other courts, they say that they will continue to consider all relevant factors when making this decision. Mm-hmm. So that's going to be the number and the severity of the violations, the extent to which unit members knew about the violations, what they call dissemination of the ULPs, the size of the unit compared to how close the election was. So if the union gets blown out, maybe they're going to take that into consideration with whether they issue a bargaining order. But in a big unit where it's just a few votes, that's going to be something they take very seriously. And then if the misconduct happens very close to the election date, that's going to be another thing that the board's going to consider when deciding whether or not to issue a remedy as a remedial bargaining order, as well as how many employees were affected within the bargaining unit. If a ULP impacted a large number of employees in the unit, that's also going to be important. So I think we can start to see that, this is going to be, it'll be interesting to see kind of how those factors play out and how few violations will start leading to these remedial orders.
Fascinating, right? It's kind of big changing.
I think so.
Big changes. Yeah, exactly. Be very interesting to see how it all plays out.
Yeah. So, I think, the remedial bargaining orders here, they really get the headline. I think that that's what people were, most interested in, and the board's press release, they had a little quippy saying that I thought was helpful. The board, in releasing the decision, said, under Cemex, the employer is free to use the board's election procedure, but it's never free to abuse it.
Ah, that was good. That's
good. And so that goes to say that, if they want to test the majority support, if they really want an election when the union comes to them with cards of more than half the unit, they're free to do that. But they kind of do that at their own risk. And they can't do that as an effort to stall or an effort to try and take advantage of that time to undermine the election. I think that this decision really refocuses the analysis. It under the old rules, the question was, can, with more traditional remedies, we effectively rerun the election in a way that we think will be fair, right? That was what the board was really asking before. And now they're focusing on this election, right? Did the employer's conduct undermine this election so much that we think that those authorization cards are now more reliable to tell us what the employees want? Ultimately, the act always goes back to protecting the rights of the employees, I think, and their right to freely choose a representative. which, I think is, comes back to why, the board is taking this big step. We've seen for now decades that the status quo was not effective. I think this decision significantly lowers the bar for ordering a remedial bargaining order. They clarify it doesn't change the standard for what amounts to an unfair labor practice.
Right.
Right. The employer still has to violate the law to get into this trouble. Right. But before, these bargaining orders were treated as a last resort. And, they essentially seem to be a default remedy in these cases now, so long as the violations, sufficiently undermine the election and that the election needs to be set aside. Like I said, potentially having just a single violation during the critical period that could result in a bargaining order. That's a big change from before. And so on one hand, we could end up with a lot of cases ending in, with remedial bargaining orders after, the union could still have to fight the good fight and go to the board and show that the employer engaged in misconduct. And as a result, they may be able to leave the board, not with, another aggressive campaign in front of them, but with a bargaining order. But the other thing that this hopefully will do is change the way that employers approach organizing campaigns.
Right.
Previously employers were almost incentivized to draw out the election process and push the boundaries of what the law allowed. They could work aggressively to try and undermine the union. Their tactics were certainly proven effective over the years. And the risk of violating the law was pretty low, right? In most cases, except in the most extreme examples, committing unfair labor practices to win an election was just going to result in another election. It was going to kick the can down the road. It was going to, it's going to be months or years before, the issue kind of comes to a question again. And, there's no saying that the employer won't continue to engage in similar behavior the next time the election comes up, right? And that's something that the board considered. That's, always a possibility. So, the impact of prior ULPs, often ended in long-lasting litigation where the union support fizzled, right? The workers, are just kind of, they're in a really tough spot in that situation where the employer won't kind of allow them to have a fair election. And they're under the thumb during that whole time. But, a remedial bargaining order, that's a significant deterrent, right? All of a sudden the stakes are a lot higher. If, a member of the employer's team, if, one of those steering committee members, a supervisor or manager, if they violate the law, if they're, surveilling union activity, if they're trying to intimidate people or interrogate people about their union activity, the company is going to be ordered to recognize and bargain with the union. They're essentially forfeiting the election by committing these unfair labor practices and by violating the rules of the election process. And so, the requirements that employer, in addition to these remedial bargaining orders, which I think is the real punch here, I do think it matters that employers now, are obligated to act promptly. They have, an affirmative duty now when they're presented with a potential majority authorization. And, now I think it's certainly, it's not an easy process, but, the employers are going to have to think carefully about how they want to respond when a union comes to them with, valid cards for more than 50% of the union. And, we may see that more employers are, relying on that majority authorization because going to an election is now going to be time consuming and expensive and really risky. Right.
Right.
So, that's another thing to think about of how it changes their calculus.
Right. And also, if you think about it too, I mean, in the bargaining campaigns I've been involved with in the past, this let's just say when there was bad behavior by, representatives of management, it was kind of like, well, But now under this, the top management's really going to have to keep closer tabs on what their,
Right.
the underlings are doing, so to speak.
Yeah.
They're responsible for it now.
Right.
Gosh, I remember I was with a campaign and, we had filed all sorts of ULPs. I'm going back 20 years ago.
Yeah.
And I remember the top boss saying, I paper my garage with the ULPs. And that was always the frustration, the lack of enforcement,
Right. And I think that that's a common criticism of labor law in general, right? That the remedies available to people that are victims of labor law violations are inadequate. They're frequently asking the employer to just do what they should have done the whole time, and maybe, tell people that they violated the law, right?
Right.
That's what we're asking of them. And so, it's rare that feels like a real consequence, punishment for what they did, or a deterrent to not do it in the first place.
Exactly.
I think that that's a real concern, but this case, hopefully could mark a turn in how the employer works. Certainly in Cemex, and I think it's common in a lot of these situations, when they're spending over $1 million to bring in people to train all of their managers, and it ends up in a situation with such egregious violations, what do people say? It's a feature, not a bug, right? I think that this part of their campaign was to really test the limits, and that's going to be a losing strategy in the long run under Cemex. So the one thing to remember, the case is on appeal.
Right.
The employer did appeal it to the Ninth Circuit, which is the Federal Court of Appeals out west. And this was in California and Nevada, so it covers those areas. I think the employer, Cemex, and then, interest groups that are going to be behind this as well are certainly motivated to try and challenge the board's decision. I think in reading it, I think the board took steps to try and make it, so that overturning it will be hard. I think that they tried to show how the decision neatly fit within standing precedent and within their authority to fashion remedial orders. But, if it does get to the Supreme Court, we've seen just in the last year or two, I'm trying to remember when that case came out, but the court's not particularly friendly to administrative agencies, rolling back the EPA's authority. And they're also, not particularly friends of workers, where the court has more conservative than when it instituted the Janus decision, or, which was a major change in precedent at the time. Other things. So something to be a little weary of, but, we can be hopeful. And certainly for right now, it makes a big difference.
Exactly. So interesting. So I'm going to ask Andrew, I know we're on Facebook Live right now, so we're asking people, if you're watching, you have any questions, feel free to put it in the chat. Andrew, do we have any questions? I don't think so. I don't see it in the private chat. I think you did such a thorough job going through it.
I hope so. There's a lot here. I think that it's an interesting case that we'll have to see exactly how it plays out. There's a real avenue for the board to continue to take an aggressive tact in how frequently they issue these remedies. It'll be interesting to see where they draw the line as to, like I said, applying those standards and when they're going to say that the bargaining order is still appropriate. By reading the guidance from the general counsel, the general counsel pushed for this. She pushed for more, I think, in litigating this case. So she's taking an aggressive stance that, this will be a very common practice if employers continue to behave how they have in the past. So it's interesting to see.
So we do have a question. So it's what's the next level of appeal? So the decision was made, the employer appealed it. You said to the Ninth Circuit? Yeah. So the board initially issued a decision, and that itself is kind of we'll call it an initial appellate review. So the case was first heard by an administrative law judge
who had, many, many days of hearings and heard from many witnesses and ultimately made the record. And then the board issued this decision as the agency's final decision. The employer first question, asked for reconsideration. So they first went back to the board and said, kind of, are you sure? Here's all the arguments why we think you're wrong. And the board denied that. And so it's been appealed to the Ninth Circuit Court of Appeals, which is the federal appeals court. And, they're in the process of hearing that case. I was trying to look to see if anything was scheduled. They've already received what we call amicus briefs, briefs from other interested parties. So it's moving along, but, they'll need to hear an oral argument on it and then initially enter a decision. And then if a party is still aggrieved, depending on which way the court comes out, they'll have the opportunity to petition to go to the Supreme Court. The Supreme Court may or may not take the case, but this is one where, you feel like they're pretty likely to pull it up. So.
And if the Supreme Court, for those of us who are not lawyers, so we can understand. Yeah. So if the Supreme Court does not decide to take the case up, it's a decision of the Ninth Circuit stands. Is that? Yeah.
So that would stand if the Supreme Court chose not to take the case.
Gotcha.
So some of it depends on what the Ninth Circuit says, but yeah. So Great. That's how it would go for appeal. And it's a long process. So, we'll have to see exactly how long it takes to get there and what the arguments are. And, hopefully in the meantime, the case will do a lot of good and, we can hope for a good decision too. So.
Exactly. Great. Any other questions, guys? We'll give it a minute. So this is terrific. Thank you so much. I read this stuff and my eyes go, what? It's really great to go through it and really kind of understand the context, like what was the process before, go through the context. So great. So thank you. We don't have any other questions. So this recording will be still on the Labor Guilders page. We keep it there. If you're a dues paying member, we're also going to upload it on the membership dashboard. So you'll be able to go right there, get a whole bunch of material that's there just for you. Thank you so much, Dan, for joining us tonight. And for our viewers, for more information about the Labor Guild, our upcoming session 2 for spring and some other workshops we're having, check out our website. So thank you very much, Dan. Really appreciate it.
Thank you so much. It's been great to be here. I always love participating in the Labor Guild events. I look forward to doing it in the future.
Great. Thank you. Take care. Bye-bye.
Bye.